Between 2016 and 2023, over 500 women have been killed. The majority of those murdered were below the age of 35 years and were killed by intimate partners or people known to them. According to the Africa Data Hub, a regional network of data organization that traces such killing based on newspaper reports, it states that about 500 women have been killed in Kenya from January 2016 to 2023. Let me draw ourselves back home. In an article published by the Daily Nation on 27th of January 2024, it indicates that 16 women have been killed since January 2020. The most disturbing was a case of Rita Mweni, a 20-year-old student at Jomo Kenyatta University of Agriculture and Technology, who was lured to a short accommodation apartment at Roysambu, commonly known as Airbnb. She was murdered, her body was dismembered, her head was dumped at a different location, and one can only but consider the words said by Dr. Jansen Odol, the pathologist. And these were his words. He said, "This is the first time I've come across such an incident in my forensic life. I have never come across such an incident." And so when we are considering the public's denunciation of a crime, one cannot live outside the prevailing circumstance in the society. It is the understanding of this court that these reports speak to a situation whereby the social fabric of the society has been torn into two, right at the middle. The court must then live to its role to protect the society. And so, having ruled out a non-custodial sentence, and may I just say this, the accused person is also not even asking for a non-custodial sentence. I read the submissions on mitigation, and in their own writing, they tell this court, Muratetu did not declare a death sentence to be mandatory, but then the court can give a custodial sentence. They say a custodial. There is nowhere in that report where this court is being invited to consider a non-custodial sentence. So we are at a stage of a custodial sentence. And I've already made reference to the sentences that this court can pronounce under Section 22. Fast track the judgment. The following factors have been considered by this court as I come to the tail end of the judgment. And there are only 3 sentences that are open to the court: a sentence for a term of years, life imprisonment, or death. The question that we all must ask is this: how many years, and what would be the basis for those years? Secondly, and for the lawyers before me, and today I am well populated, thank you for coming. We are all aware of the jurisprudence on life imprisonment, where one of the courts has said it is unconstitutional. The latest decision which I've quoted in this matter says that life imprisonment is 30 years. So the question that one would then ask is, if life imprisonment, and of course is acceptable, it doesn't mean the life which that person will physically live or be alive. So if it's 30 years and with remission, then we'll be looking at where this court is sentencing the accused person to 30 years. With remission, he serves 20 years and his life moves on. These are issues the court had to think of. I have, of course, taken into account issues of human rights. I've taken into account Article 26, that says a person's life should not just be deprived without good reason. I have made reference, maybe I should then let you know, to the international instruments that speak, and I need to do this because it's important, to the preservation and the right to enhance an individual's human rights. The International Convention on Civil and Political Rights, which has been ratified and which then, of course, becomes part of our law under Article 2, Sub-Article 5 and 6, says this, and it's important that I read it out because you need to know that. It starts by saying every human being has the right to life. And I stop there and I tell myself as a quote, every human being has a right to life. That every human being includes the victim and the offender. It then says this. This right shall be protected by law. No one shall be arbitrarily deprived of his life. Most of the time when we read these provisions, we speak to them as they relate to the offender. My understanding is they relate to both the offender and the victim. That convention states as follows: that in countries that have not abolished the death penalty, a sentence of death may be imposed only for the most serious crimes in accordance with the law in force at the time of the commission of the crime. So these international instruments that speak to human rights do recognize that there are exceptional circumstances when the death sentence may be inevitable. Let's look at Article 4 of the Africa Charter on Human Rights, on Human and People's Rights, ratified on 23rd of January 1992. It provides that human beings are inviolable. Every human being shall be entitled to respect for his life. This, in my considered opinion, includes her life, and the integrity of his or her person. Again, it reiterates, no one may be arbitrarily deprived of these rights. Muratetu reflected again. The Supreme Court says that you can indeed impose a death sentence for most serious offenses, extremely grave. So the question is this a case of serious crime? In answering that question, I considered the following. What the evidence said. And the first thing that was revealed by the evidence is the manner in which the offense was committed. I want to remind ourselves of the judgment I delivered on 9th of February, where I indicated clearly that the evidence of the doctor who conducted the post-mortem report indicated that the person who perpetrated this offense cut the throat of the deceased through and through. In that judgment, I spoke to an understanding that the person was not an amateur. The person must have had some training. And remember, the evidence even revealed that after the offense was committed, the deceased was put in the bathtub and the shower tap was put over to run the blood off. When I read the report presented by the probation department, where the accused person himself says, I have been trained by the Dubai Police Academy and an Ogara group, I thought that corroborates the finding of this court that there was full scale for commission of the offense. I do recall saying in that judgment that the manner in which the offense was committed did not at any time intend to give the deceased one more minute to live. I do recall throughout the trial, no any other than the counsel representing the accused person in this trial throughout kept on referring to the incident and the scene of crime as a slaughterhouse. Secondly, we have had the benefit of looking at the photographs showing the body of the deceased and the injuries. I would certainly not display them there, certainly not, at least for the benefit of the family. And I did indicate in my judgment, no one would like to look at them again, not once, but twice. Now, let's look at, and this is very critical, because it is not the court just making an observation, it was a brutal murder. Let's look at how the defense, that is the submissions in mitigation by the accused person himself, describes the offense. I will now read to you how they describe the offense verbatimly. They say that it is a tragic, heinous loss of life on extreme circumstances, bordering on an act of absolute madness that is beyond understanding. So even the defense joins the victim's family and the prosecution and the court in arriving at the conclusion it was a gruesome murder. Horrific, frightening. Let's now look at another important aspect that the court has considered. The consequences of the offense. From where I sit as a court, each one of us is responsible for the natural and the probable consequences of our actions and or omission. So it's not just an issue of committing an offense, but the far-reaching consequences of that offense cannot be ignored. And so in this case, it is undisputed that the deceased was the managing director of the family's business in South Sudan. It is undisputed that the business collapsed after her demise. It is undisputed that that was the source of income for the family, and we can all appreciate the natural and probable consequences of that. I have already made reference to the fact that the other consequence of this offense is what has been described, and unless there is evidence to the contrary, I believed it because it's in the probation officer's report that the mother of the deceased suffered depression and stroke, and she has hardly healed. I've spoken to what the brother is said to be undergoing. This court, and I never lose out on anything, but try to get as much of in-depth of the material before me as I can, has been invited to take cognizance of the fact that the father of the deceased at one time said, I will let go. That did not form part of my record, because what formed part of the court's record is his sentiments as expressed in the brigade report, and that is what I would safely go by. But I'll be concluding with one or two other findings that could probably remove us from that mind thought that the father said, do not, vengeance is not mine. I also want us to just, in concluding, other than looking at the manner in which the offense was committed and the consequence or the impact of the offense, I took a bit of time to look at the character of the accused person. I have already spoken to how the probation officer describes him: aggressive, and social personality, and concludes he has double personality traits. But let's look at what else this court was able to gather while hearing this matter on the character of the accused person. It was the evidence of the guards at Royal Park Estate, where he was staying, that he would not allow himself to be searched. He would brandish a gun and say, I work at State House, and just drive off. It is the evidence of the brother of the deceased that even during the hearing of this case, at one time, he blocked his car when the case was going on. And of course, you have heard from there, even when he was out on bond, he was still involved. I'm not condemning him because there's no charge before me. But the court cannot avoid looking at this. Because at the end of the day, the question is this: is this a person you want to release back to the society? And these issues become extremely critical for consideration. Finally, this matter and the evidence adduced does not lead to a conclusion that this murder was accidental. That the perpetrator did not have an opportunity to think about the consequences of his action. It was intentional. It was not a defensive act. It was not out of provocation. It was planned. It was intended, and it was executed. And those who do not subscribe to Christian faith, bear with me. I do. That's the only place I could make reference to. In the book of Job, chapter 1, verse 12 to 13. This is what is written. I think I looked at the, was it NIV? You can find out, speaks to the same thing. This is what the Lord said to Satan. Behold, all that he has is yours. Only do not lay a hand on his person. I'll repeat. Behold, all that he has is yours and is in your power. Only do not lay your hand on his person. The provision of life is the preserve of God. And I find no room anywhere for a person to take another person's life unlawfully. In my very final conclusion, join me in listening to these wise sayings on murder. 1. In the act of murder, one person's life ends, but countless number of lives are forever impacted. I will read again. In an act of murder, one person's life ends, but a countless number of lives are forever impacted. Secondly, murder leaves behind a trail of shattered dreams and broken hearts that can never be healed. Murder leaves behind a trail of shattered dreams and broken hearts that can never be healed. I have said the accused person before me is 33 years. The deceased was 28 years. Thirdly, the act of murder is a heinous crime that challenges the moral fabric of society and demands justice. And so it is not just a loss to the immediate family. Of course, it is in the highest degree, but it's a loss to the society when one is killed unlawfully. And so, based on everything I have said, I have ordered that the first accused person before this court being Joseph Kuria Irungu alias Jowie, shall suffer death as provided for the offense of murder under section 204 of the Penal Code of Kenya. And is that sentence is lawfully set aside by a court of competent jurisdiction. That is the order of the court. Thank you.
Lady.
Yes, Council.
Yes, my lady. For purposes of appeal, we pray to be provided with copies of copies of the judgments and sentencing decision and tax proceedings.
Any other council wish to address the court?
My lady, the sheriff for the state, apologies I was late. We just want to thank the courts for bringing this matter to a close. We're in alignment with your sentence, and we still would like a copy of the sentencing ruling once it's available. But we are grateful for the court's indulgence and the way it has handled this matter. Thank you, my lady.
Any other?
Yes, my lady, on behalf of the victim's family, we would also wish to thank the court most sincerely. The manner in which the court has handled the proceedings, the family feel that justice has been done. We also wish that the court supplies us with copy of the sentence and judgment once the same is ready. Thank you.
Okay. A right of appeal is a constitutional right which the accused person should feel free to exercise, is important. You are entitled to the proceedings, the judgment that the court will delivered on today's judgment. And when the file was brought to me, and I'm sure by now my judgment is available. It was actually available the same day I delivered before 7. So just ask the Honorable DR to give you the proceedings and the judgment. I've always said that my judgment is never accessible until I've delivered. My judgment on sentence is here. As I was delivering, I could say quite a bit of typo. So it's just an issue of polishing it. You should have a copy. I'll sign a copy before end of day, and you should have a copy. Okay? So unless there is any other person who is addressing the court, may I have the last bite of the cherry? First and foremost, please allow me to sincerely thank all of you. And that means the parties in the matter, the members of the public, the press, for the support you have given this court. I took over this matter from my brother Justice Wakiaga. And as much as I know there's been a bit of complaint that it's taken long, we did the best we could. We lost a bit of time during COVID when activities of the court slowed down. But take it from me, when you look at the way this matter, I'm not blowing my own trumpet, I have no reason to. But one thing we must appreciate, that this matter was being had alongside other matters. And let me say something that probably you wouldn't know. When I was presiding in the criminal division of the High Court here in Nairobi before I was transferred, I did a prison visit at the Nairobi remand, and those inmates took me on this matter. And their question was, kwa nini unakimbiza kesi ya Jowie na Maribe na walituacha hapa na uendeshi kesi yetu haraka? I didn't realize that we were moving fast with this matter. So for the members of the public who have felt that when we talk about only 6 years, it's also important to consider that there are other matters. And so please, we are not making an excuse for anything, but it's good to just make an understanding and of course, apologize for any inconvenience that may have been caused by any delay in the hearing of this matter, but set the record clear, we did the best we could. And so I thank you for your support, because other than the time we had a bit of challenge when I think Professor Nandwa had a personal issue, all the time the lawyers were in court. and we were able to move on. I have not had a disruption in this matter. The press, I must really congratulate you. I have not had to summon you here to say, what did you report? Except recently, which I will not talk to, but maybe I should. When I was reported to have said something which was said when I was still driving to this place, and I was still on my way here. And I'm reported to have said that the accused person, Jacqueline Maribe, must come to court even when she's sick. I don't know where, was it KTN or what other media house reported. Sikujua hiyo wametoa wapi, lakini msijali, hiyo imeisha. Iliisha hivyo tu. You know, you must also choose the battles to fight. But what I'm saying is that generally speaking, I really want to thank you. I know you are quite a number of you, and you are understanding, but I've not had any reason to complain that you have not reported these matters factually correct. So thank you very much. Please keep up the good job you're doing. For the rest of us, thank you for coming, supporting the judiciary as it were. Your patience with us is highly appreciated. And with that, I wish you a good day for the rest of the day. For our staff, the court assistant, and of course, my other good friends, I can even see one whom I've worked with for a long time, the gentleman there. Umefanya kazi miaka ngapi? Over 10, eh? Please don't say anything more, they'll start guessing my age. So thank you very much, court assistant. Unless we have any other matters that are before the court, I would request then we officially adjourn the court.
The court is adjourned.